affected. Great Eastern also is affected because the fines nowadays is very high and very strict. Total they already paid 180 million this year. Maybank already paid to Ben Negara fine. So you see, it's becoming more and more strict. So we have to follow and comply all those requirements, market conduct essential, Ben Negara guidelines. Don't breach anything like anyway. Great Eastern is very compliant company. So automatically before even it becomes a problem, they will solve it. Okay, good afternoon everybody. Welcome for the program. We are talking about liability. Uh, there are two type of insurances format in the market under general insurance. One is the normal uh, uh, insurance product like fire, motor, where your client is covering his house, his car, his stock. So when there is a claim, we settle it directly. Whereas in liability, your customer is not having damage to his property. Your customer is not injured, but due to his conduct of his business, somebody else, third party, people who come in contact with your customer, they are injured because there is a duty of care imposed by the law, common law. Everybody has to provide a duty of care. So your customer did not provide the duty of care to the third party, so he got injured in the office, and he wants to sue you. So insurance company now will defend you against the suit by the third party. So it's a bit different. We are not having physical damage, but we are having a financial financial difficulty, financial burden. That is what we are trying to cover. And this financial burden upfront, we do not know how much. Only when it goes to court, then the court will decide how much. So it's quite difficult in the sense to come up with some insurance, but we will go through and understand this product carefully, so that we can promote to our clients. 2 days ago, we did general liability, and we did director and officers insurance. So that's two also is liability product. So general liability was talking about operational. Any businesses must have this cover. And I also mentioned the other day, there are two important things in this coverage. One is territorial limit. Where can you operate? You can operate in Malaysia, so territory limit Malaysia. And the other one is jurisdiction. Jurisdiction means which law will apply, which country law will apply. So if you are operating in Malaysia, Malaysian law lah. So these two are very important. Jurisdiction Malaysia, territory also Malaysia. So unlike some of the product like marine cargo, you are sending to Hong Kong, the incident happened in Hong Kong, territorial limit is including Hong Kong, and also the law is Hong Kong law, where the event happened, the jurisdiction is Hong Kong. So we got to be careful how we treat each of these products. First of all, we need to understand the coverage. The first one was general liability. The second one we'll talk about was director officer. Director officer, we're talking about administrative duties, decision making process where the decision was wrong and impact somebody, and then they are injured. They have a financial loss. So they want to sue back. Today, we are talking about product. People who are manufacturing product. This product used in the market cause injury or cause property damage to third party who are using your product. They want to sue. They say that you never take a proper duty of care. You breach your duty of care, therefore causing us to have an injury. And then later we'll talk about professional indemnity. Professional indemnity is the error in the advice you give. Because you give the wrong advice, they have a loss, financial loss, they want to claim against you. You go to court, you are the lawyer, you fight their case, but you never present your case properly, they lost, they feel very upset, they want to sue you. Okay. You have a duty of care as a professional to provide proper advice, competent advice. These are the two things that we are going to talk about today. So anytime you have any questions, you can unmute also, no problem. Or you can go to the chat box, like how we say good afternoon, Wing Kiong. Yeah, put in your statement here and then we will review. Don't be shy. Just put whatever you feel because we want to discuss. If you don't put, I don't know what problem you are facing or what issue you want to discuss. So put here freely. Whether it is related to the topic or not, it is my duty to explain to you. I will explain to you. Could be something else. Doesn't matter. Okay, good day. Reliance Network Services. Yeah. Don't worry about your question. Just put your question as it is. We will discuss one by one. And then we will take a break, 1 hour's time, maybe about 3:30 like that, and then we will carry on for the second part until we finish. Yeah. The more questions you ask, the more discussion we have. The afternoon to make it more lively. Yeah. That is the whole objective. Or you can use a reaction button also. Chan Ching Hong, ask question over here. And then you can use this button also to put thumbs up or clap, or I don't know what is this. Thanks. Many things you can do. So just use it. Good. Okay. Radio Network already start putting questions. Good. Put. Don't worry. Just leave the question there. I won't touch the questions yet. I will leave your question there for a while until we are moving, and then I will come to this question. When in between, when I finish a certain area, I will come back here and I will check. That's the time I will answer your your question. Not now. Now I just want to start off and start get things moving. Meanwhile, you put more questions there. Don't worry. Oh, so many questions there. Really, how I going to answer? Don't worry. I will answer it. Okay. But I want to structure it properly before I start. Very good. You ask question. I'm very happy. Okay. Yeah. With that, we will resume the class. Okay. So today we are going to talk about liability. Liability is very strongly related to the law. There are many types of law. Got civil law, criminal law. We will discuss. There are strict liability. There are contributory negative liability. There are the 6 things I say very important. The 6 things we will talk somewhere inside here. We will talk about negligence. We will talk about tort. We will talk about breach of duty of care, and then we talk about what type of cases people can take against our client, and then how to defend. How to defend very important. Yeah. So we'll talk about all these law-related issues on public liability or liability product to this product. Able to explain the coverage provided under the product liability and professional indemnity. So you meet your clients, you can solve the question that you asked here just now. Doctors have their PI under MAA. Can we still sell to them? If the Medical Association of Malaysia provides a basic cover, and the doctor feels that the basic cover is insufficient to cover him, he can you can sell it to him bigger cover, because it all depends on how much work he is doing, how much exposure he's having. Is he specialized? Is he a normal doctor? Uh, what is his annual turnover? Uh, any claims experience? How many doctors are in the clinic or in the hospital that you want to cover? Yeah. So answer is yes, we can cover, provided that he wants to top up top up his basic cover. Can discuss and do that. No problem, because the amount is not enough. MMA provide basic. Like the lawyers also same. The what is that? Bar council provide a basic cover. Then they always go outside and get a bigger cover. Okay, ready enough? Okay, that is the answer for your question. So to understand how retroactive applies. So now in these liability policies, sometimes there are two type of cases. One we call it occurrence basis. One we call it claims made basis. So occurrence is like your car insurance. You meet accident, you claim, you have a policy, they will pay you. But in liability, you make a claims made. It's a claims made basis different. Occurrence means when it occur, you will claim and you pay during that period. Claims made, today you got a policy and then you want to make a claim. The claim could be related to some decision you made long time ago, 3 years ago. The architect decided to draw his building in this manner. Nothing happened. Everything okay. Now after 3 years, the building collapsed. You have a policy. Policy is related to some previous period that's called retroactive. Retroactive means going back dating. But this policy will pay. Not the old policy. Yeah, this policy will pay. So retroactive is like backdating. It's allowed in liability, provided there is no pre-existing claims. If you've got pre-existing claims already, or somebody want to sue you, then you're going to buy the policy that defeats the purpose already. Yeah. To review the exclusion. So we also look at some exclusion, how it works, and most important is buyback. If it's not suitable to you, extend back into the policy. Look at terms and conditions. These are the areas that we want to review lah for today. Okay. First product we talk is product liability. You know, in the US, this lady, she driving the car to the McDonald's. So she stopped at McDonald's. She ordered the hot coffee, and then the drive-through hot coffee, she put between her thighs, and then she moved the whole hot coffee spill on her thighs, burn, second degree burn or third degree burn. So she want to sue McDonald's. Why your coffee injure me? Product is coffee. So McDonald CEO went up to the national TV and said, that woman is stupid. People buy coffee, they got put near the thighs. You know the coffee is very hot. Keep it safe and don't spill it. So he said, we are not going to pay her anything. In the national TV, he went and said that. In the US, they have a juris method lah. Jury means they call few people. Okay, a normal citizen sit down in the jury and listen the case and then discuss and make a decision. So the judge easy. He listen to the jury, he understand the jury, and then he can make a decision. Most of the time, the judge will follow the jury lah. If the judge doesn't agree with the jury, he can override the jury. Just let you know. But most of the time, they just follow because many people already think about it and make a decision. This time, the jury say, we are very fed up with McDonald. So cocky. The CEO go on the national TV and make this announcement. We are going to make him lose. So at the end, McDonald had to pay the lady 1 million for her injury. And then what happened after that? McDonald's or KFC or whatever, fast food, all change their product. They have the cup, they have the cover, they're hot, they put warning, please careful, spilled hot coffee can cause injury, all these things they started putting. Because of the product product liability. Today here we will discuss afterwards what do you mean by manufacturing? What are the things involved in manufacturing? And then what do you mean by product? And how product liability will cover this product. This is the approach that we're going to take. Yeah. Okay. So let's go on. Every businesses can expose to negligence. So come back to the same point. Key point is negligent. Negligent means the radio I got highlight. So I'm a reminder to you. Negligent means careless. Careless and cause injury. Unintentional. Careless and unintentional. That is negligent. If it is deliberate, that is fraud and deliberate dishonesty, we won't pay the claim. So people sometimes can be careless and cause injury. That's negligent. Negligent is part of the big word. The big word is called tort. T-O-R-T, tort. Tort means civil wrong. Something wrong you made against somebody. Could be a negligent. So negligent is part of tort. Or could be something else. That something action you made was wrong. Defamation. You talk bad about people. See, that's a civil wrong. You are doing something wrong. But most of the time we talk about negligence. Okay, so people can be exposed to carelessness or negligence during their business dealing. All business owners are required to exercise duty of care. So yesterday, on the 12th episode, we were talking about duty of care. Duty of care is very important because under the law, which is called common law, everyone has to provide a duty of care to whoever they are meeting, including the neighbors. Neighbors means indirect. Direct affecting you, indirect means your neighbor, next person. So we still have a duty of care. If you remember, we were talking about this lady called Donique. She went to a store to buy things, and a friend also went with her. A friend bought in a bottle of ginger beer and then gave to this Donique as a gift. Inside the ginger beer bottle got a snail, but cannot see lah. The color is so black, cannot see. She drink and then she got sick, and then she sue the Stevenson. Stevenson is the owner of the shop lah that was selling this ginger beer. And then the lawyer said that Stephen, you have a duty of care. You are negligent. The snail go into the bottle. You have to pay compensation to my client, Donique. But the court at that time, the judge was Lord Atkins. He's the judge who proceeded this proceedings. And then there is no case before that. This is very early times, the 1940s or something like that. There is no such case before. Because this lady, Donique, never bought the bottle. The ginger beer she didn't buy. She got it as a gift. So there is no contract between the lady Donique and the shop owner, Stevenson. So there's no contract. How can you sue me? That is what the other lawyer is saying. There's no contract. How can you sue me? But this Donique's lawyer is trying to make it clear that even though there's no contract, the product is yours. If you're making product, you must take care of everyone around you, including the secondary or the neighbor. Whether they bought it or they used it, as long as your product, you are responsible. You have a duty of care. You see. So the judge, that's the ruling they make lah. Negligent by carelessness caused the snail to go into the bottle during the manufacturing process. And then even though there's no contract, no direct link, there is an indirect link. Indirect link is called neighbor. That's what the neighbor concept of a neighbor. A neighbor is a third party lah, who is affected by your doing. So you see, even the bottle also, product must have a product liability. Otherwise you have problem. So the lady won lah. She claim against the ginger beer retailer, not you. The manufacturer. Sorry, manufacturer is Stevenson. Yeah. So a breach of duty of care can result in a lawsuit. If Donique is sick, she can sue the person who made the ginger beer by the agreed third party. So Donique is the third party. Same, the lady who took the coffee in McDonald's, she got burned, she got bodily injury. She can sue against McDonald's saying that they breach of duty of care or they are negligent. A defective product that did not perform according to its specification caused injury, and the user has a right to sue, including property damage or bodily injury. There was one time in Malaysia, the CEO of one company, he charged his phone under the bed, under the pillow, and then the thing exploded and he died. He can sue. The family can sue the manufacturer of the phone or the manufacturer of the charger, whoever liable for the injury or the death of the person. Product that did not act according to their specification. Product can be defect from the design stage. No check even come to the public. Design stage already got problem. Or during the manufacturing process on the line, online, operative line on the line, production line can go wrong. Or after production line package already want to send out, the sending out can have problem. The warning don't have, not clear warning, not clear instruction, cause injury to the party they want to sue. Product must have proper label, proper description, proper warning, marketing. Your marketing message must be right. Everything is part of a product. I go to Bangsa, Hartama side there. Sometimes I see this Japanese shop or Korean shop. I'm not sure. So I go inside there. I want to buy their product. Everything is in Japanese language. How can I understand? Where is the warning? Where is the label? Where is the instruction? I can sue the shop owner if I am sick because of eating their product. See? That is what we're talking about. Incompetent advice by professional. You are a lawyer. You are taking this case. You should make sure you study the case properly. What is the case study? Yeah, there are many resources that they can use. If something to do with religion, they can use the federal constitution. Federal constitution give right to everybody to pray according to your own religion, to have a right to talk, a right to educate, a right, so many rights. So if people block you in your religion, use the federal constitution will support the lawyer. Never use federal constitution. Incompetent advice by the professional, and she lose the case. Then now lose the case, they want to sue the lawyer. You see, can lah. Or use precedent case. Already got similar incident like the snail in the bottle case. Today you drink some Coca-Cola bottle, and then one lipas come out from the Coca-Cola bottle. Same lah. So the lawyer easy only. They say refer to Donahue and Stevenson case. The ginger beer and the snail inside there, similar. The judge make this decision, so we follow lah. So some cases already make decision. So it's called case precedent. Sometimes you look at the judges, the senior judge, they do write books, book of authority, their opinion about certain matters. You can use that also to fight the case. You can use custom. If it is practiced for many years, it becomes a custom. That is the way we do things here. So many ways to fight the case. But the incompetent professional never use. When you never use, then they get into problem, and then they want to sue you. Or a doctor, my right hand paining, he go and check my left hand, and then my right hand is actually fractured. I'm in pain, but he put a plaster on the left hand. Now both hand cannot use. One plaster already, one fractured already. Incompetent advice, incompetent services or advice together. Cause a financial loss, including legal fees. Administrative decision. You are the head of department, you make a decision, let's close down Sabah Sarawak because Sabah Sarawak not much business. And then all the staff in the Sabah Sarawak branch, they want to sue you. Administrative decision, which is a wrongful act. You never did a proper study. If it is a correct thing, it's okay, but it's a wrong thing, you can end up with a financial suit. All this involve lawyers. All this involve the courts. All this involve huge amount in legal fees. So your sum insured must be sufficient, because we cover not only bodily injury or property damage, we also cover the legal fees. Although the necessary precaution may have been managed and handled, the dealing effectively, efficiently, you do your best, you have procedure, you have OSHA, you have all this smooth operation, efficient and effective operation. But risk is always unexpected. Uncertainty can happen. So you need to have a protection by buying insurance. Without a suitable specialized liability product. Why we use the word specialized? We're talking about two products here. We're talking about product liability. After that, we're talking about professional indemnity. So the starting is the same for both. If the product cause injury, product liability. If your advice goes wrong, professional indemnity, both are there. Without a suitable specialized liability product, we can potentially face financial burden if we are found to be negligent in our dealings with customers and or third parties, whoever. So this product liability and professional indemnity cover lawsuits by third party and customers, which are member of the public, clients and customers against The lawyer, the professional, or the product. Yeah. Example, Honda. Last time I was using Honda Accord. In the Honda Accord also, I got one message by the chairman of Honda Japan. Japan write the letter to me. Oh. Say, we sincerely apologize for the inconvenient cost as you need to go and replace your Takata airbag. For airbag problem. So this is called a product recall. Honda Malaysia issued a recall of 23,476 vehicles to replace the Takata front airbag. Honda Malaysia sincerely apologized for the inconvenience caused to customer once again. As customer safety is always our top priority, the company believes that this replacement is necessary as a precaution action and urge affected customers to replace them. So the product liability don't cover recall. We are only covering if the airbag cause injury to somebody. Somebody wants to sue the Honda manufacturer. They install the airbag, Takata airbag. Takata airbag manufacturer must have a product liability insurance that will pay for this injury of the person who is using the car. You want to call back everything is because more incident will happen. You are scared, so you want to bring back the car. That one is different. That's product recall. Can have an insurance. You can calculate and see how much. But normally, this is for the big boys. We are more worried about the simple Toyota, Camry in the Europe. Driving, suddenly put the brake not brake also not happening. Hit the tree, the person died, and then they call back the product. Same thing same with the Honda. So people can get injured using your product. People can property can get damaged if there is a defect in your product. So you need to be protected. Car manufacturer, whoever want to put in parts, accessory parts like the Takata airbag or battery or car tires or steering rod or windows or doors, they will need to come with a product liability. Only then Honda will allow them. Otherwise, they won't allow. So Honda will have one for the entire car, and all the parts will have a product liability cover, so that any good thing goes wrong, they are covered. But recall, no. Doctor accused of causing death, patient death. Singapore, a doctor accused of causing death, patient death after aesthetic treatment. Anesthetic treatment. Aesthetic treatment was handed 3 more charges under the Health Product Act on Tuesday, including 2 involving expired medication. So the medication they use already expired. Aesthetic. What is it? One minute. Beauty product. Aesthetic is beauty product. So the cream they put for you, your face becomes worse. The medication they use was expired medication semua. So they go after this patient, this doctor. Chan Bingyi, 34, was first charged in the court on October 11 over alleged means suspected only lah. So must do investigation to find out whether it's true or not. Negligent, suspected negligence, suspected carelessness for administering and ethylene acid. What a long name. It's the longest name I saw in my life. EDTA. Intravenously, that means we use the injection, through injection into the body, into the bloodstream. To loudly think when there's no need to do it. On top of that, the medicine already expired. Beauty products, very dangerous. So many times we hear people die, people get sick, become worse because taking all this product which is not certified or certified or done wrongly by the doctor. So professional indemnity, wrong, negligent in advice, negligent in services. I can cover under this professional indemnity, example. More question in the chat box. Are we okay so far, the chat box? Radiance Network, Sanjayan Bahat. Are we okay? Others, are we okay? Can you all hear me? Can we have the reaction button to confirm we are okay? Okay. Others, okay. Total life management. Okay. So far we just touching the examples. Meanwhile, you can put into the chat box if you have any question. Examples of why product liability is important, why professional indemnity is important. And because insurance, we have to cover the six important principles. Every time we do, we have to do this. No choice. Because this is the basic. 60% to 70% of the product is talking about this. If you do a construction job, you need to know the concept of construction, the type of material you use, the type of piling that you're going to do, the structure, how you're going to lay the structure. That is construction. If you do insurance, you need to know the concept of insurance. The concept of insurance, you must have an insurable interest. First one. Normal car, you are the owner, it's okay. Now you are not the owner, third party claiming against you. But if they lose the case because of common law, you have to pay. So you have a financial interest, financial burden, financial interest. So you can take out the policy. So insurable interest must be there. Utmost good faith. When you buy this insurance, you must put in all the information. Most of the liability policy is based on occupation. Different occupation got different risks. Estimate annual fees. 1 year, how big is your company? 1 year, how much do you do? Number of staff handling clients. Got each staff and clients open for claim. Number of branches you have, how big is your operation, annual fees that you charge, your claim experience. These are the things we need to know. In the proposal form, we'll ask all these questions. Utmost good faith. In good faith, you have to answer all these questions. And then we have contribution. Contribution means you have two policy covering the same item. When it comes to claim, they have to share proportionately. Approximate cost. This approximate cost, no approximate sub P. Approximate cost. What is the main cost of the loss? Is it covered? Oh, approximate cost is something that already exists, pre-existing, not covered. So sometimes it is covered, sometimes it's not covered. We need to establish the approximate cost, whether it's covered or not. Advice given, or the product exploded, or the advice given was careless. Or subrogation. Subrogation means after we pay the claim, we want to sue the person who caused the damage. The neighbor played firecrackers, your factory is got burned, I have to pay for the fire insurance, and then I sue the neighbor. Subrogation. I recover back my losses from the third party who caused the fire to happen. Indemnity. To put you back same position. So that you are not losing. Cannot make a profit from a loss. Same position can. To put you back to the same position as you were as immediately before the loss. Cannot make a profit from a loss. All these are important principles. What we want to discuss is these principles align to the subject matter we are discussing today, liability. So we look at the yellow box. Okay. Insurable interest. A product exploded and caused injury, user had to go for plastic surgery to redo the face. Not so bad compared to the other person who died. The whole skull damaged. Sometimes you go to the restaurant and then you order the food and then they make their special food and then you eat and you got food poisoning. Okay, product is the food. Sometimes you buy in the plastic the food, reprocessed food, also got food poisoning. You use the car, you press the brake, the car accelerated and damaged. Many products are manufactured out there. And if there's a defect in the product, can cause injury. Whether it's going up for a plastic surgery or death to somebody, you are liable to pay for the loss. You have an insurable interest because it's your product. Okay, you are liable for it. A customer engaged the services of a lawyer, but the law firm overlooked an important aspect of the case. You are the lawyer, you never review properly, you left out important part of the case lost. End up financial burden 100,000, award given to against your client, and the legal fees you want to pay. So your client not happy, they sue you lah. CEO of a reputable company make an error in a decision that caused employee to lose 5 million in the investment opportunity. The CEO say, we want to sell all the shares that we have. So they sell the shares, they make loss 5 million. When they have lost 5 million, the not enough fund to carry on business, we have to cut resources. We cut the staff, we cut here, cut everybody, take action against the company CEO. Director and officers liability. Yeah, as a director and officer of the company, as a person responsible for making decision, don't make a wrongful act. If you want to sell the share, call a meeting, make it a joint effort, joint decision, committee meeting, ESCO meeting. You see, I last 6 months, I very actively training QBE insurance underwriters. Twice a week I go there and then I train them of all the classes of insurance and the underwriting and the policy wording, everything I covered. The fire tariff got 17 section, each section I covered word by word. So the CEO very smart. In order to approve my training, he called for an EXCO meeting. So in the EXCO meeting, he asked everybody's opinion. So everybody agree. Then he say, this decision is an EXCO decision. EXCO means the committee decision. And we will follow the committee decision. See, he never make his decision. But my training was good. Everybody was happy. So EXCO gets the name. But if something go wrong, it also protect the CEO. I never make the decision. EXCO make all the EXCO design are better. Yeah. So in making decision, there could be an error, and making the wrong decision, error, you can upset the stakeholders, people who have interest in your company, and then when you upset stakeholders, they have losses, they will claim against you. We talk about the turf club. Turf club, yeah, turf club. Two committee members of the turf club, they got insider information. They heard, oh, this Fountain Network, some company being listed in the public listing, they are going to shoot up the price. So immediately they put in 31 million. They want to make it double to 62 million. And when they go listing, instead of going up, it went down. The members of the club got very angry. They called for an extraordinary general meeting. They want to sue the committee. Why they make a decision to put the money in the share market? So the committee members next time when they make decision, call for a meeting and then call for a general or extraordinary general meeting. Ask the members, all the members, got any objection or not? We want to buy this. Let everybody agree. Once everybody agree, nobody take blame. That's called rightful decision. Now, when you do decision without the ESCO, without the committee, it's called wrongful action. When you do wrongful action, you are liable. That is director and officer liability. All insurance needs material fact. Material fact are important information for underwriting decision making process. That's very, very critical. We need to understand your trade, your operation, number of staff making decision, experience of the staff, experience of the company, any prior known claims. Remember, we say retroactive can go backwards. If already got prior known claims, and then optionally we're not going to cover those claims. Claim experience, yeah. How old is the company? Is it a new company? When the company was established? So we want to decide on the retroactive cover. How many years we want to go back dating? According to law, I said only 6 years can go. Limitation Act. And then we talk about contribution. You buy a policy from the agent, and then you buy the policy from the bank. Two policy covering the same item, and then there's a fire. You cannot make claim two sides. Then you make a profit already. So when you buy insurance with two different uh, sellers, you have to share proportionately. Your share, your sum insured, divide with everybody's sum insured times the loss. So your insured, sum insured is 50,000. The bank bought 100,000. The loss is 20,000. So the agent policy will pay 50,000 divide by 150,000. 150,000 means your policy 50,000, the bank policy 100,000. Add up together 150. So your policy is 50,000 divided by 150,000 times the loss, 20,000 loss. The bank will pay their sum insured 100,000 divided by 150,000 times the loss. That's called proportionately. And then you got proximate cost is correct word. Proximate cost. What is the main cause of the loss? Improper and insufficient product instruction. People don't understand how to use your product. And because they don't understand how to use the product, they got injured. And when they injured, they sue you on the pretext of insufficient product instruction. So, negligent, careless, pay the claim. As long as innocent, A careless diagnosis done by the doctor can end up with the wrong prescription. The left hand paining, repair the right hand. Eyes paining, repair the ear. Brain paining, repair the stomach. I don't know lah. A careless diagnosis done by the doctor can end up with the wrong prescription, causing injury, illnesses, permanent and temporary, to patient. A wrongful act by the director, a decision by the director can cause a suit against any of the stakeholder. Any stakeholder, shareholder who wants to sue, they can sue. So proximate cost will allow you to pay. All three events is careless, wrongful act, covered under the policy. Subrogation, if you got more than, if the neighbor is the one caused the damage to you, we will pay you. After we pay you, we'll go after the neighbor. You got your advice, traditional medicine, you are a doctor. Anyway, you give traditional medicine, not covered. So cannot. Example not good. Let's look at another example. Yeah. So, you depended on the preceding case to fight the case for your customer, but the preceding case was from the senior judge book of authority, and then you presented the book of authority, and then it turned out that the information in the book of authority from Thomas Thompson was inaccurate. But you use it so negligent, we have to pay the claim. After we pay the claim, we will sue Thomas Thompson for his negligence and error in his book. That caused our client to lose the case. Okay, now subrogation. You will recover back from the person who is at fault. Many companies now, they set up a subrogation department. Every time there's a claim, they want to see where they can recover back, who can pay the claim. Indemnity. Indemnity is to put you back to the same position as you were as before the loss. But in liability, we don't call it sum insured. We say limit of liability here, limit of indemnity. Limit of indemnity or limit of liability. So you cover 1 million, the judge say your limit of liability is 500,000. So we pay only 500,000. Because at the front we do not know. That's why I say all liability policy, after go to court only we will know. So we need to come up with some figure before we start. So 1 million. The insurer will compensate only the amount based upon the judgment amount. Yeah. The award will be limited to the limit of liability selected by the client, which is the maximum sum insured. So whatever limit of liability you select, that would be your uh, sum insured. So I said don't cover too small because nowadays the awards are bigger. So you cover bigger sum insured. Doesn't matter. The difference in the pricing is very minimal. Okay. That is on the subject matter. Okay, guys. Any question here in the chat box? I'm at the chat box now. Before we go into the law, some areas about the law. No question. All okay, Ong Woon Lee. Okay. That one Nurul, I think, putting the thumbs up. Okay, let's go on. Yeah. So the law. There are two types of law. One is civil law, one is criminal law. The thief observed the bungalow. Observe, look at the bungalow, and then one day decided to break into the bungalow lah. So he climbed up the roof. He removed the roof and he entered. Unfortunately, the ceiling is so thin. He put his leg, he fall down straight onto the floor. Broke his leg. The owner woke up, saw, hey, the thief here. Call the police, come, take this fella. Pencuri sudah kena tangkap. The pencuri making noise. Wait, you owner, hopeless owner lah. Why can't you make your ceiling properly? See, I got injured already. I'm going to sue you lah, Mr. Owner, for your ceiling not done properly. So, according to the law, you cannot break into people's house. That is called trespassing. If trespassing is a criminal offense, when it is a criminal offense, the government will take action against you. The public prosecutor will take action against you. Prosecutor will take action against you. You can go to jail, can get fined, and then you have to go through the authority. Authority is handling you, not the owner of the house. The owner of a house not happy with you, that is individual. When it is individual, we call it civil case. But now the thief not happy with the owner. The thief saying the owner is not careful lah, caused me to have injury lah. I want to sue back the owner. So the owner is liable for the case. The owner have to pay the whatever he have to pay to the thief lah. But by law, if you are doing something illegal, extropy, something like that. Extropy, they call it. If you are doing something illegal, the law will not protect you. You cannot be, and you get injured while doing it, you cannot be protected by the law. So if the thief come in, he's doing something wrong, trespassing, and he got injured, it is not the responsibility of the owner of the house. So both case he lost. Civil case also lost, criminal claim also lost. That is to tell you there are two type of case lah. So civil law, criminal law. Civil law is individual between the thief and the owner of the house, between your policy holder and Great Eastern. They come a contract, insured and insurer. That is civil lah. You pay me premium, anything happen, I pay you the claim. Private in nature between two people. When you are not happy, you summon him, writ or summon letter, or sue him. And then when you sue him, the award is a remedy. How much they pay you? For your inconvenient cost, they pay you 50,000 like that lah. That's it, settle the case. Individuals, between two parties. That is called civil. This is between the thief and the owner of the house. The thief fall down inside, break trespassing and came into the premises. That is a criminal. State will take action. You are doing a crime against the state. The duty of the state, or state here is government, is to protect the citizen. In order to protect the citizen, the government will come up with law. The law will be under penal code. The penal code will say this is wrong, this is wrong, this is wrong, this is wrong. So all the wrong things they highlight, please don't do all these wrong things. Do the right things other than that. So when you break the law, then you do the wrong thing, the state will take action against you. Public prosecutor will take action against you. And when you take action and they found you guilty, then you have to jail, fine, or death sentences. Money laundering, criminal breach of trust. That is against the state criminal things, against the penal code. So the public prosecutor will take action against you. Bribery, rasuah, public prosecutor will take action against you. But you see in Malaysia, sometimes the public prosecutor say, never mind lah, it's okay lah, that one is Zahid only lah, let it be lah, deputy prime minister no need take action lah, this one no need take action lah, this one Mahathir lah, no need take action. So if the public prosecutor, the state don't want to take action, cannot happen anything. The state must take action and then go to court and decide whether that's the case or not. And then if that's the case, then only they will start the proceedings. And then when you found guilty, I see lah, go jail. How many years jail? A fine, penalty, death sentence if drug related, all penal code. This is all against the government, against the state. That's called criminal. We are not into this area. We are into the area of civil law, civil, between the insured and the insurer. Important section. In order to claim that the other party is liable, you need to prove. So burden of proof is with the claimant, the third party. I got injured. I came to your restaurant. When I was sitting in your restaurant, suddenly your kitchen exploded and one part of the besi, the iron, hit my hand. My hand is fractured. I'm suing you. Proof. Doctor, what is that? X-ray or MRI and the report, any scanning on the brain, any problem or not. And then doctors, attending physicians report, the bill from the hospital, all these proof, photograph showing that you are injured. Burden of proof is with the client. They need to prove that they have a injury. And insurance company job is to investigate only. How? Loss adjuster, you go and check lah, this one talking correct or not. So they will appoint loss adjuster to do the investigation. The loss adjuster will check. If the loss adjuster finds that there is no case, they will say we don't want to pay the claim. So burden of proof is the customer must prove. Insurance company don't have to prove. We only investigate. Yeah. Okay, good. Let's see if we have any questions there. Are we okay, ladies and gentlemen? Please put on your questions. That was a good question under PI for MMA. Any other questions about product? Exposure, causing damages, causing injury, covered or not, this product, let that happen, this product happen. Then we can discuss lah. Okay, otherwise, Kairina say, very good explanation, no need to ask questions. Okay, let's go into the product liability. So, before I start product liability, sometimes the product can cause problem. But the insurance policy got exclusion, not covered. Doesn't mean you cannot claim. Please go ahead and claim, but claim in the court against the other person directly lah. Insurance policy won't pay, but you can still claim on your own. The insurance indemnifies. Indemnify means put you back to the same position against all sum, whatever sum insured you have covered, limit of liability you have covered, which the insured becomes legally liability. Go to the court. The court have to decide whether it is liable or not. So legally must be liable to pay for bodily injury. Using your product, the exploded, the head got big hole. Add your product, become sick. Put the facial product, becomes dark. or wrinkles or accidental damage to your property. Yeah, use a product to polish your bag. LV bag becomes, instead of becoming shiny, becomes spoiled because of the product. So you can screw the product under the whatever they use to shine the bag if it is not working. Two things, property damage and bodily injury or death. Cover also legal expenses. Legal expenses is also very important. It's also covered. The problem with liability is the legal expenses is very expensive. So come back to our main point again. When you buy the sum insured, at the time you buying the product, we do not know sum insured. We only can see the exposure. Yeah. We don't know sum insured, we only have exposure. Based on the exposure, you have a limit. And I also say small limit or big limit, the amount is not much different. Might as well take $1,000,000 lah. At least $1 million cover for your client. Don't take small amount. The legal fee will eat you up. The policy, wait, the insurance indemnify the insured against all sum which the insured becomes legally liable. The court finds that you are liable in respect of bodily injury to third party or illnesses, sick or skin becomes affected, arising or loss or damage to property to third party arising of using the product, misusing the product. Product say do this way, you use another way. Also cause problem, you are still liable, but less lah. If you use the product the correct way and cause injury to people, then the court will say strict liability. If the injury cause a financial burden of 100,000, we have to pay 100,000. If you use the product in a misused manner and cause injury to the person, we still have to pay, but it is contributory negligence. Your product caused the problem, but my attitude of not using it correctly also caused the problem. So share the loss. Contributory negligence. So they say, you are claiming 100,000, we only pay you 60,000. 40,000 is your own problem because of misuse of the product. But we still have to pay. Consumption, eating the food, eating the tablet pills for enhancing our appearances, using the facial to make ourselves, beautify ourselves. Consumption or handling of the insurance product, putting on the hand or handling or using the product, the steering rod, using the product or the phone calling or whatever, causing bodily injury, causing property damage. The policy will also pay for the cost of incurred in defending. The legal costs, very expensive, the legal costs could be a major item. So your sum insured must be sufficient. The insurer will not pay for the cost of removing. Just now we say product recall. Please bring back all the Honda Accord. 24,000. That one we cannot claim. That's your own cost. But there is a product also lah, called insurance product recall. In case any of the product was not functioning, we need to call back all the products. Insurance will pay for the cost. Again, that's a different product. We are not talking about the product. The product liability does not cover that. But I saw some American products, they combine product, first section, product liability, second section, product recall. Very hard to do. But let's focus only on product liability, the product causing the liability. Not necessarily the product or the part or some part of the product causing liability. So we will not pay for your car bang into the gate, removing your car, recalling back all the other cars, replacing, repairing defective products. That's not under our jurisdiction. Our product risk that we are covering is injury to other people. Other people's product are damaged, third party product, third party body injury. Your product we are not covering. You got to buy a different insurance. Maybe all risk insurance, maybe recall insurance, some other insurance. If your product is damaged or you want to repair your product, that is a different area. Okay, who is a manufacturer? So sometimes we get confused, who is the manufacturer, who is responsible. So manufacturer we need to understand, product we need to understand, product causing liability we need to understand. So three things we need to understand. Four things, one more thing. Consumer Act, when there is an issue with your product, what does the law say about it? How you handle your product? Defective product already, then how the law say you need to handle. So that's under Consumer Act. So there are four parts of the discussion here. So let's we do a bit more before we take a tea break. Yeah, we do a bit more. So who is a manufacturer? To manufacture a product, you always start with the design. You want to make a phone, you create the design. You want to make a sports car, you create the design. You want to make any product, you have to have a design. So the design is the start of the entire process of manufacturing. After you have decided, you go and get all the parts to make the product. Maybe you do a pilot testing to see the product working or not. Once the product is working, then you go and order, and then you put a production line, and then you start assembling part and part, mix, becomes the product. So that is production line. So first part, design. Second part, in the production line. The product is going to production line. Sometimes because the design is already out, the entire production line also no point out. Sometimes design is okay, production line, one product go out, other product can use. So it all depends on the production line. Assembling the product, fabricating, sometimes you need to fabricate to fix it, construct it into a product like a car, and go through all the processes, painting, fixing, and coming out and packaging it. That is the manufacturing only. So manufacturing starts with design, goes into the assembly line, finish good, package it, stop. That is manufacturing. Now we want to sell this product, we got to make it attractive, we got to see what is the pro and cons about the product, we got to do product labeling, we got to do advertisement, we got to do a lot of other things, warning, other things. So we move into the product. So once the product already packaged, so manufacturing moves into product. Manufacturing, design, assembling, package already done. Now we give you the product, already packaged product. So we talk about the product now. Or otherwise, prepare a product or component part prior to its sale to consumer, to a consumer or user product. So once you package it, now becomes product. Product means what? Product is a bigger definition. Product is talking about how you want to distribute this product, all the selling points, proposition about the product, the description, what the product can do, the warning, what you should not be doing, the labeling, okay, including the package that you're going to put the product, the container, the part and accessories comes along with the product, all instruction, how to use the product, how labeling, all the warnings about the product, about the warranty about the product, guarantee how long the product can use, marketing, where marketing material, advertising, instruction, information about the product is called the product. So now the product is out from the factory, it's already manufactured. Now the product itself, now we need to put in packaging, another layer of packaging, labeling, instruction manual, warning, warranty, service warranty, and then we got all the labels all done ready. Then we talk about how to market this product outside. Now we're going to go outside and market the product. Product shall mean any tangible product. That means we do not talk about software application, cyber insurance, or computer insurance. So we are talking about a tangible product manufactured, already left the control of the participant. Participant is warehouse. Manufacturer is what manufacturer. Uh, Participant here manufacturer. So what happened is that first slide you saw manufacturing, design, assembling, fabricating, construction, done, packaging. The second section you got the product itself. You need to do boxing, labeling, warning, warranty book, this book, all done. Now the product goes out of your warehouse. The moment it leaves your warehouse, product liability starts. The moment it is in your warehouse, you are still in the warehouse warranty, warehouse insurance. You're covering stock, finished goods, burglary, fire, whatever happened to the stock. It's still in the part of it. But the moment you leave the factory, it becomes a product, tangible product, which has been designed for a specific purposes, specified how to use it, formula, you got sometimes chemical formula, facial, they got to mix properly, chemical, formulated, and then manufactured, mixed, constructed, installed, sold now to the customer, supplied and distributed, already tested, service, or altered or repair on behalf of the warehouse or manufacturer. So now it's gone out already. The moment it goes out, sold or supplied to retail outlet, wholesaler, or retailer, the second part comes into play. Anything can happen once your product leaves your premises. This is what we want to cover in product liability. Okay. Let's look at any questions. Guys, any questions you have? No, all good. Think about questions and put it here. Now is 3:15. Okay, let's do a bit more 3:20, and we take 25 minutes lah. 3:45 we will start, but just I won't stop yet lah. Just I do a bit more. Unless you got question, I can take any questions now. Good. 3:45 we will start, but I will do a bit 5 more minutes, and then only I will break. So let me just go to the type of claim first. Let me finish this slide, and then we will take the break until 3:45. Okay. Type of claims can come in. Product liability claims can be brought in by any third party, anybody using your product. Then they got an injury, there is a death, or the property damage caused by your product, which had gone through the manufacturing process, the assembly line, the design, the formula, the presentation, the materials, the installation with the warning, instruction, marketing, packaging, and any area it hits, you can come in with a product liability claim. They may say that the injury is because of a defect in your design, doesn't work the way you have designed it. The injury is caused by a formula, not right mixture of the formula. The injury because you never give me proper instruction. I don't know how to use it properly. The injury because the packaging, I use the packaging. The packaging is not right, and then cause injury to me. Or where you give me instruct to combine parts to make it a final product. Also not proper instruction and then I got injured. So injury can come anywhere along the line. Yeah, let's take a break. Okay, I'll see you at 3:45. Okay. Meanwhile, put any question that you have. I will address it. I'll see you in a while. Okay. Damage, but the cost of it could be at the manufacturing. Just now we talk about manufacturing. When we say cost of manufacturing, they're talking about the design. Something wrong with the design now give me bodily injury. Or the assembly line, something went wrong, the product did not come out properly, defect in the product. And the packaging also. That's the first part. Second part is talking about the product itself. The instruction not clear. The warning is not clear. The marketing is confusing. That caused me to have injury. Yeah, packaging, labeling of any product, testing. Sometimes in the formula, that's assembly. During the assembly, you need to formulate mixture, chemical mixture not right, preparation not right, assembly, installation. Anywhere the claim can come in, can cause somebody to take an action. That's a type of claims that can come in. So traditional cause of action by the court when the plaintiff, the third party, takes the case to the court because he say I am injured due to any of one of these. The court can say after hearing all your defense and your claim, we want the company to be 100% liable. So strict liability. He's claiming for 100%, we have to pay 100%. That's the action. They're claiming for 100%, or can be contributory. The judge can say half half. Action is the cause of action is that because you breached the duty of care, you were negligent in preparing the product. You breached the warranty wording. Sometimes it is written, sometimes it's implied. Implied means no need to give instruction, you know how to use the product. Implied, assume. Otherwise, written express. You fail to warn me that this product cannot put outside, must put in the fridge. You never tell me to put in the fridge because I never put in the fridge. I put outside. Now I put on my face. Now my face is so horrible already. Post sale duty of warning. Never did. Failure to provide instruction how to use the product. So I use the product my own way lah. When I use the product my own way, then I got problem. You see. So I want to sue you now. Misrepresentation. You say the product is the best in the world. Your product, you got so many people using the product successful in weight, reducing weight. I use the product, I increase weight. Misrepresentation. You never tell me that I'm not supposed to eat also in the same time. Okay lah. Non-disclosure, hiding information. There are side effect. You hide. You don't tell them about the side effect. Must take water lah. Must take this one lah. Otherwise, it will cause a problem in the body lah. So that are some of the action, traditional causes of action. And then what does the Consumer Act 1999 says? If your product is a defect product and the Consumer Act says you cannot distribute defective product, prohibited to distribute defective product, you need to recall back the product. Finish lah. You need to stop selling this product, stop sales, stop advertising about the product. You must let the public know about the weaknesses of your product. Finish lah. What are the things that make your product unsafe? What is the warning that you need to put in? You need to repair and replace your product at the nearest repair center, or refund back. Change the product for a refund. So this is what the Consumer Protection Act says. And if you don't comply and you still use the product and cause injury to people, then they sue you. That's where becoming public product liability will come in. This is before it becomes a major issue with other people. There's somebody already injured, so they ask you to stop distributing your product. This under Malaysian Consumer Protection Act. What are the causes of liability? Your error, design stage already got error. All the way through, you do whatever you like, you're not going to improve anything. You can put the best marketing strategy, best wordings, best warning, already defect in the design stage. In the production stage, got problem. Design okay lah. Production line never follow the proper formula, never follow the proper construction, never follow the proper fabrication, never follow the proper line, fall down, mixture, whatever happen in the production line. Some products are affected, some products are not affected, or all the products are not affected. Or production line come out okay already. Now come to packaging also done okay already. Now you need to install all the wordings, marketing, instruction, warning, all this labeling, other materials you got to put. Inadequate, never inform me properly that I got to be careful, got to put in the fridge. Stay away from young babies, cannot. Pregnant lady cannot use the product. You got to give some instruction lah. No label warning. So now the defense is Great Eastern and your customer together form a party. We will fight against the third party. We will defend ourselves. Our lawyers will defend your customer, your policy holder. We will say, hey, the product you know is defected. Why are you using the product? Your fault. So from strict liability becomes contributory liability. From 100% claim comes to 80% or 70% claim, because you are also contributing to the claim. Product, like you cannot escape. Product manufacturer will have to pay the claim, but amount is less because the other person know there is a product defect and he still use the product, or he misused the product. Product is supposed to put only on the face. What is that? Misuse of the product. You know the product is supposed to be put in the fridge and then use it properly. You misuse the product, supposed to put on the hands. You see your hands so nice, you put the product, you put on your face also. Not it's a facial product, it's a hand product. Misuse of product. Then you want to claim. Alteration and modification of product. You saw your product very good. You say, I want to make the product better. I go and add in other things to make it even better, but become worse. Alteration and modification of product. Criminal tampering. This one is competitor. Not happy you are having a big market share. Not happy your product is flying. So they tamper with your product. They put something in your product, make it poisonous, make it ineffective, make it dangerous, so that your brain is affected. They can sell their product. So you want to prove, very hard to prove lah. But we can do that. We can do that. Competitor buy the product and then competitor want to claim against you. But we know that he's a competitor. Then you need to prove lah. Hire private investigator. Statute of limitation. Now under the law, there is one law called Limitation Act. It's a statute lah. Under Limitation Act, anybody wants to sue for any damages or injuries, he got to do it within 6 years. That is the period allowed lah. This product is more than 6 years already. Your injury after 8 years you coming to claim, cannot. Within 6 years you must come and claim. You cannot claim more than 6 years. Yeah. Another area is that there's a lifespan in your product. The lifespan say 10 years. After 10 years, don't use the product anymore lah. Change the product to a new product lah. That's what it means lah. Limitation And then when go to court, the court make a decision. The court will pay compensation. The compensation the court pay is for your suffering, your pain and suffering. How much? 100,000. Loss of wages. 2 months cannot go to work, cannot earn money. 2 months loss of wages. Loss of earning capacity. From now onwards, I cannot earn normal already. My salary going to go down by 25% because I'm not capable. I got a bit handicapped already. So loss of earning capacity cannot earn. Medical bills, funeral bills, and that's the first pen compensate back lah. And then got death happen, wrongful death, another amount, another 100,000 here, wrongful death. Future medical, now onwards for your entire life you need to buy these tablets and go for future medical checkup, future medical expenses so much. One lump sum I give you lah. Cost or loss of consortium. Husband losing the wife. The wife is the one got injured. The wife died. So loss of partnership, loss of consortium. Husband losing the wife. So that is an area. Family member losing, loss of consortium, loss of your companion. Lawyer's fees, more very high lawyer's fees. So don't take small amount Take a big amount If you lose the case, you got to pay all this, 100, 1 million already. Punitive damages. Punitive means punishment for what you have done. Punishment. So the punishment, punitive and punishment, if it's a fine by the government, then we cannot pay that. That is fine and penalty. It's not covered under the policy. Yeah. Then consequences from product liability. What are the consequences? If you don't buy product liability, the medical expenses so high. Other expenses so high. You have to bear with it. Medical insurance, Bank Negara last year allowed the insurance company to increase the medical because they all complaining medical expenses is very high. So Bank Negara allowed this year all the insurance company increase their medical insurance. I last year hit 60. I got one increase in medical. This year, another increase because portfolio repricing. They reprice the entire portfolio because Bank Negara allowed. Everybody did it, so everybody price going up. So medical expenses is going up. Every time it go up. Lawyer's fee is a killer lah. This is the highest. The lawyer's fee is very expensive. Loss of privileges and control. Because your product affected people, the people mouth will start talking everywhere like a fire. When they talk everywhere, then you lose privileges as an agent of the product, control of the product. People don't want to buy, you lose a lot of things. You can have an unpredictable financial impact, if effect or impact. Cannot sell the product already, people don't want to buy. So all this you have to look into a consequence of product liability. Your name in the market becomes bad. The product becomes bad. You got to find a new product. Share market go down, loss of share market. People don't want to distribute your product. Difficult and inability to secure additional distributor. People don't want to distribute your product. How? Yeah. So because of the impact is very great, you need to buy a product liability. If you have a product liability, you don't have to worry about the medical expenses. The product liability will pay for the medical expenses. You don't have to worry about the lawyer's fees. The product liability will cover the lawyer's fees. Then don't have to worry about all these privileges because you already handled you at the tip. You nip the button at the tip. You stop it from overflowing. You stop the problem because you have the funds. Product liability will cover that. Then you do advertising lah to recorrect the position. Rebranding, renaming product. Last time AIG in US, they were giving out loans. Their product is giving out loans. Their product you can buy, you can take the same house, you can take 7 times the loan. I don't know what they're doing. So 7 times you can take the loan on the same house. So when the market went down, they cannot collect the money. It's one person taking 7 times loan on his house. How are you going to service the loan? So bad reputation. Nobody wants to buy the AIG product. So they change name. One of the ways you change name from AIG, they change to Chartis. But after everybody quiet already, they got financially strong again. Then they do advertising. They improve their product, their company name, their branding. Then they go back to the normal name. So that's the life cycle of product branding. Yeah. Okay, that's it on product. A lot of we discussed already about product. Anybody want to share anything else on product? I am at the chat box now. Are we all okay? Doctors have their PA. Hey, this one we done already. Why you ask the same question? Oh, no, we started time. Sorry. Sorry, we are already here. Yeah, all yes. Any question? Anybody typing any question? Please keep on typing. Okay, let's go on to the next product. Professional indemnity. Just now we're talking about product. Product we say cause injury, cause property damage to third party, plus the legal fees. Now we're talking about advice. Professional advice. When you give professional advice, you got fees. So you are expert in your field and you are giving advice, and based on the advice you are giving, you are getting some fees. A lawyer who is a qualified lawyer is protecting his client, and then he's giving all those preceding cases, fight for the lawyer as a professional, services and advice to protect his customer. And then his customer lost because the lawyer never do a good job. Error and omission in giving the advice. Incompetent advice. Insufficient advice. The customer not happy, the customer can sue the lawyer. The lawyer needs to have an indemnity, professional indemnity. Some ask MMA, Malaysian Medical Association, already giving mandatory professional indemnity insurance for all the doctors. But some doctors are specialized. Some doctors are doing many cases, huge accounts. So they need to have an extra policy for their own. Better to have your own extra policy, yeah, if the amount from MMA is insufficient to cover their liability. Lah. Yeah. Now, one point I want to raise is this. A professional is anyone who is giving advice for a fees. That's it. As long as you are giving advice for a fee, you are considered a professional. An agent is a professional insurance man who's giving advice on insurance to his customer. If you give wrong advice to the customer and he have a risk, a loss, he will come back after you. You need a professional indemnity, yeah. A trainer like me, I'm giving you so much information, and then all my information is incorrect. When my information is incorrect and anything happened to you, then you can sue me for not for error in my advice or insufficient or incompetent in advice. So this is in the area of advice. When you come to underwriting, it's different a bit. Some underwriters say, in order for me to cover you, I need to know your qualification. So they look at lawyer degree, accountant, professional paper, medical degree, any degree that you have to support your professional. As long as your degree, the underwriter is willing to look at it. But that doesn't mean that you cannot be covered under professional indemnity. Coverage for professional indemnity is covering any professional advice or services that you give. Underwriting got their own criteria, more stringent, what risk they want and what risk they don't want. That is the point I'm raising here. Because I don't want you say, underwriting reject. So actually, professional indemnity do not cover anybody who don't have professional papers. It's not like that. Everybody can be covered as long as you are earning income from the services that you give. But underwriting criteria may be different. Let's leave it to the underwriters. They know how to look at it. Provides protection for professionals in conduct of their practice and profession. In conduct of their practice and profession means in line with their expertise. A doctor talking to the client, examining the client, and then in between telling him, hey, you buy lah, the bungalow in Bangsa going very cheap lah, sure go up one lah. Then you go and buy the bungalow, go down tomorrow. And then you want to sue the doctor. And doctor got professional indemnity insurance. But that one doesn't cover him. Because that is not his expertise. The expertise must be in the proposal form. If you think that you are real estate expert, you put in the proposal form, I want to cover one, my doctor profession, two, I want to cover my side job, which is a real estate negotiator. If you mention that underwriting accept, then you can cover lah. In your area of expertise has put in the proposal form. Covers professionals in case they breach their professional duty. Earlier we said duty of care, breach the duty of care. Now we say professional because we're talking about the advice they are giving out in line with their professionalism. Professionals have a duty of care. Yeah. They must exercise due care and skill in giving advice, in fighting for the customer, looking at precedent cases, in treating the patient, looking at the correct diagnosis, and don't give a wrong prescription. The left leg is injured and you treat the right leg. You leave all the instrument in the stomach. The lady got childbirth, cesarean, they cut the stomach, they take out the baby and they put the instruments inside the stomach accidentally. Careless, negligent, unintentional. You know lah, all this I'm talking about. So many example I give you already. Cover professional for their negligence, careless, but it is not purposely. If it is fraudulently, we won't cover. Error and omission, mistakes that they make, careless mistakes in servicing performed by them to their clients, third party. Who you can cover? You can cover yourself. If you got partnership, Ahmad and Ali partnership, both. You can cover your company and all the directors in the company. You bought a company, the previous directors also, if they have any problem, you want to cover them. Past directors or predecessors, previous directors, you want to cover also can. Future directors, you want to cover also can. Because the error and omission can come from anywhere. Professional have a duty of care, service, due care and skill when they are providing services to their clients and the provision of professional advice and services to third party. If the third party suffers loss after relying on your professional advice, they are entitled to recover their losses from the professional who provided the services. If you don't have an insurance policy, indemnity insurance policy, you are asking trouble. Number one, can impact your entire business, can go on a loss. Your reputation, your company's reputation can go into the drain. Your company can be bankrupt. All the funds eaten up by the claim. Your asset, you have to sell your house, you have to sell your bungalows, you have to sell all your properties and stay in the hut, in the jungle, maybe. Decline in your standard of living. Cannot use aircon, cannot use fan. Go on charity lah, what to do. So before this happen to you, please make sure you buy a professional indemnity. Wow, very clever lah. Now, when you buy this professional indemnity, again, it is claims made. Claims made means this is your period of cover. This is a retroactive back. You start the firm here. You start your firm here 5 years ago. So claim happen here. You claim here. If this is Great Eastern, you claim from Great Eastern lah. Okay. But it is related to something that happened during the retrospect. You were handling a claim of a client here, the client you started handling here, the mistake you did here. Never mind. As long as nobody knows about it, no prior event, then it is covered. Here, not covered. Here is not covered. Policy expired, not covered. So only claims made here to cover anything happened to your company during the retrospective period. This policy will pay. Must be in provision of your professional service. Must be something to do with what you put in the proposal form, which we agreed. Must be within your professional boundary of your profession, declared in the proposal form. Must be from third party, not related, not your family, not your employee. Third party who come for service, ask you consultancy, ask you your opinion or use your services. Claims made can be retroactive to an earlier date. Yeah. Okay. What does it not cover? Why come there? Wait, just give me a minute. Okay. So what is does not cover prior known claims before somebody is already making a claims against you. You already know the claim is coming in. You know there's a claim coming in, and then you want to buy insurance to cover. You cannot. Pre-existing. You see, many policies got pre-existing, prior known claims, prior circumstances. Already know there. You want to buy insurance so that you can claim? No, cannot. Fraud, dishonesty. No, it must be negligent. The word negligent is careless and unintentional, which is a thought, silver wrong, not a fraud or dishonesty. Claims made by related or associate entity. Your partner got another company doing the work. They are being sued. You cannot use your policy to cover them. Your policy is for your organization. That policy must cover his own policy. You cannot use your policy. Related associate subsidiary company cannot. Must be specific person and specific company. Fine and penalty. Just now we say, fine and penalty is not paid because fine and penalty is actually a punishment for you because you did something wrong. The government, the money goes to the government, doesn't go to anybody anyway. So fine and penalty is a lesson for you, punishment. Goods manufactured, not here. We are talking about professional indemnity, professional advice. Earlier, before the tea break, yeah, we are talking about product. Yeah, that's product. So you got to buy a product liability, yeah, not a professional indemnity. Product is not a professional service. Duties assumed beyond reasonable professional standard. Well, I go back to the goods manufacturer again. Now, if you are using a machine that is manufactured for medical purposes to do MRI or to do some scanning, and you're doing consultancy, you use the machine, okay, you are doing professional services, but the machine caused the injury. That one is come under product manufacture, more product liability. Your advice is professional indemnity. Both can come together. So goods different and product different. Professional indemnity different. Duties assumed beyond reasonable standard. You are a GP, general practitioner. Your level of medicine is for clinics, okay lah, government hospitals, okay. You cannot be advising people as a specialist. Eye specialist. We're talking about all the eye things. You don't have qualification. You never state in the proposal form that you are eye specialist. See, depending on the specialties that you have, you must mention. If not, means beyond reasonable accepted standards. Services performed outside of your services, not medicine. You are a doctor. Why are you giving a lawyer's opinion? Services not performed by your firm. Your firm doesn't do all the services. Why are you claiming? Examples, You okay, right? Guys, are you all okay? Yes, no. Thumbs up. Reaction button. What about a chat box? Say okay. Lee Chai Fa. One person out of 75 people today. Certainly got 75 people. Oh, now coming in. Mutiara Resources. JIT Management. Others? Come. Comment. Okay. Good. Thank you. So let's go on. If you have questions, don't keep to yourself. We can discuss. Just type in the chat box and we will discuss. Unmute also we can discuss. We are here to learn. And by you raising the question, we learn together. Okay, let's go back. Not here. Okay. So examples of professionals is engineer. An engineer who is designing and building a building, architect designer, engineer is he manage the building, uh, construction of the building using the contractors and all that. Turn out building is inferior, building collapse. Before the engineer can sign, building collapse. CAR will have to settle it. But because of your design is wrong, your expertise is in the design, interior design. And that part, if it belongs to you, you have to bear it lah. Your professional advice on interior designing. Accountant never use the proper data, never check properly the debit credits, never check properly the accounts, and then you give wrong advice. Tax supposed to go down but go up. Tax get fined by the tax department. Yeah, you can be sued for error and omission. Real estate agent supposed to take care of all the tenants' property, look at the rental property, good condition, never check. Collect money only. Tenant destroy the premises, habis lah. We can be sued by the owners who give them the contract to take care of the properties. Property manager. They got voting going on, and then you put wrongly the vote. Instead of saying yes, it becomes no. And then it affected everybody. Miscount votes at the property owners meeting. Turf club. Turf club, the one in KLCC lah. KLCC Turf Club. Last time it's a golf, horse riding, horse racing club. So the committee member of the turf club, one of the committee member got insider trading information. He found out that this stock is going to shoot up. Mountain fountain. Okay, so he tell his committee, let's buy. This one should go up double the price. So committee put in 31 million, hoping to get 62 million. What happened? The stock crashed from 31 million go to 0 cent. All the members making noise. They want the committee member to reimburse back the 31 million. Wrongful act. As a committee, you're supposed to act correctly, wrongful act. And then DNO policy, error omission policy, not this professional indemnity. By just giving you the example, since we talk about real estate agent, real estate agent is supposed to give advice, but that one was the turf club. And then what happened? They got sued. So instead of making their own decision, they should be calling a committee. Let the committee make the decision. Sorry, call a AGM. Make a AGM. Let all vote. That's why you talk about vote. Let's vote whether we should buy or not buy. If everybody say buy, then go down. Never mind. What? Yeah, should be like that lah. Marketing consultant fail to advise best marketing approach, best promotional method to make money for the company. Surveyor misspec the land, miscalculate the land, so we have to put more cement, not enough cement, or the land size becomes smaller. Can be sued. Architect, Terengganu Stadium, make nice stadium design, fell down. Not only one time, 2 times fell down. Sign off building prematurely. Building does not meet the functionality purposes. Boardroom, not enough people can sit inside. Investment advisor, give wrong advice on the stock. Now I have to go another 10 years extra to recover back my money. All my money gone. Solicitor, lawyer, error in conveyancing, never look at precedent case, fail to protect the patent, fail to protect the invention, get sued. So you, as a professional in the field that you have put in the proposal form, make sure that you give your best advice. If there's a breach or error or omission in your part, as a professional doing the decision making or providing the services to your client, and it is found to have error or omission or negligence, you can be sued. If you have made a good decision and it doesn't turn out in your favor, it's okay. People are not upset. People are upset when you never do your best, not competent in your job. That's why you have professional. As a professional, you got to be competent in your job. So how to get the sum insured? Now I'm going to say the very important thing. Insurer, liability insurance, very hard to get the sum insured because the event haven't happened. We don't know what are we talking about. We know that it is something to do with professional advice. That's it. We got no much information. Unlike a house, you can calculate the value of the house and cover it. Stocks, you can cover the value of the stocks and cover it. Or motor, you know the motor value and cover it. Here we do not know the value. When you do not know the value, how to cover it? That is the most important critical point that we want to raise. At the time of purchasing, we do not know the value, but we can figure out the exposure. How to figure out exposure? What is your trade? What professional are you in? And then what is your annual income? We take your annual income, we times with 100. After we times with 0.2 or 0.3 can time, we get the rate and then we look at other material fact. Experience. How many years experience? The more experience, more discount you get. The less experience, less discount you get. Specialty of work, only you are doing it or other people doing it. If you are doing it very specialized work, the risk is higher. Yeah. Number of employee who is handling it. More people handling, more exposure. Where area you are doing only one office, head office, or you have branches all over the country. So many factors. All these factors can help reduce the premium value. The rate can go down, or the rate can go up if it is higher. So these are the most important. Not so much about how much sum insured. It is more about your profession, your trade, your experience, any claims. These words that we talk on this slide. Calculate the base rate after taking the minusing discount and whatever weightage you have to do, times with the annual fees, and then you got a rate. Load rate based on historical claims, circumstances, then discount. If you want to take higher excess is the first amount to be borne by a client. Say excess is 10,000 means the first 10,000 your client must pay. But your client say, I want to take higher excess, can? Can. Voluntary excess, take higher excess. Take 50,000 excess also can. Premium will go down. The more you are willing to contribute to the loss, the more we are willing to reduce the premium. If you say 10,000, only first 10,000 you are liable. If you say 50,000, up to 50,000 you are liable. So my exposure is less. When my exposure is less, I will reduce the rate. Don't underinsure. The value, sum insured is not a criteria as much as your profession. Because at the end of the day, the judge is going to make the decision. The cost difference between 100,000, 500,000 and 1 million very little. Marginal. Might as well take a higher amount because the lawyer's fee is very high. People are taking 1 million up to 5 million. Yeah. Complete the proposal form, give all the material fact, let the underwriter make his decision, give full and complete information. Yeah, that's advice. Which one you have to look retroactive? First of all, you got period of insurance. This is the period of insurance. This is where you're having Great Eastern policy. So the retroactive last year or the last few years, you also got a policy here. Maybe your policy is with Allianz. Now, you took this policy this year and there is a claims made this year. Yeah. during the policy period. So you have to claim from Great Eastern. But when Great Eastern investigate this case for the claim, it appears that the problem was somewhere here. The work was done before. The architect drawing was the year before. The services was performed earlier, but there was everything's okay. But now something went wrong. So Great Eastern will have to pay because it is within the retroactive period. If the thing went on here, then we won't pay. Before the retroactive, we won't pay. If after the retroactive here also, we won't pay. We only pay here. This area we pay. So that is how the retroactive works. Claims made. So policy cover claims arising from work performed within the retroactive period. Anything here we still cover. During the period happen also we still cover. This area all we cover. Outside here is not covered. Work performed before the retroactive date is not covered. Claims made after the policy period, of course, not covered. If the potential claim is reported, the claim will be covered for the period of potential. Claim will be covered after the policy period. If a potential claim is reported during the policy period, but they are going to settle it after, circumstances of claims made during the policy period is covered. Work can be retroactive. If claims is made after the policy expired, not covered. Yeah. Policy cover claims made and reported to insurer within the policy period. Policy is only covers claims made and reported to insurer within the policy period. So the during the period we will pay the claim. It excludes circumstances known to the insurer prior to the inception of the period. If you already know prior known claim, we're not going to pay for the claim. It's already known factor. We will not pay for the claim. It's exclusion. It must be something that we do not know it happened or not. Exclude cover claim arising from work performed prior to retroactive. Before the retroactive is so not covered. I think it's very clear already. Are we clear? Okay, right. All right. Now, one more thing I want to highlight now. Why don't we go? Let me see what is behind you. Yeah, it's already finished. But I want to cover another area. Let's take a 10 minutes break, toilet break, and then I will cover one more area which is called how to defend the case. It's got too early to stop. So 10, 35, 40, 45, 4:45. Just take 10 minutes break, toilet break, and then I will talk to you about some cases of how to manage the defense, how to manage the defense when go to court. And then at the same time, we will talk about some examples. Please, if you don't have example, we will add in some examples, more examples. Yeah, just take 10 minutes break. an operation on somebody, and he never did. And
Mr. Jess. Hi,
yeah,
Mr.
yeah,
Jess. Sorry for interrupting. I think your slides are gone.
tak keluar.
Yeah,
Okay.
because just now one of the agents suddenly take over the
Oh,
presentation, so your slides gone. Okay,
oh, dia
I can
pandai
see a
lah.
slide.
Okay. Anyway, so yeah, so the doctor sometimes does an operation and he does nothing wrong. Everything he does correctly, but somehow the patient dies, and then the next of the 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 next of kin or the family wants to take a case against the hospital lah, wants to take the case against the doctor lah. They say the doctor was negligent. So it is very hard to prove negligent, careless in doing the operation, and they must see lah the procedure lah, whether he followed all the procedures or he cut short the procedure. Everything he did correctly lah, but they still want to claim. They say that this one is not supposed to be a major surgery. It's very simple surgery. How come the person can die? So they want to take against the doctor. So some of the defense that doctor can use is there are other methods of using the defense. One of the method is called vis major. VISMAJOR, vis major. If you were on the 12th, you have noticed that I've said that as well. Vis major is that the doctor and the insurance company protecting the doctor, say Great Eastern. Great Eastern and the lawyers and the doctor can say, uh, we did everything in the best of our capabilities. This is beyond our expertise. We never did anything beyond our expertise. We followed our expertise. The outcome is beyond our expertise. It is an act of God, an act of God. Things that not under our control. If it is not under our control, how come you can blame us that we have a negligence? So there are some avenues there for you to defend cases, especially when you are indirectly responsible. You're not directly responsible. It is not under your jurisdiction, but somehow you are made to be responsible. So you can use vis major. That's a Latin word, VISMAGOR. Sometimes they use the word. Maybe you might heard some of you might have heard, some might not have heard. Forge majori. Forge majori means act of God also in Latin. There is a change in regulation, there is change in procedures, there is change of medical treatment, there's a new medical treatment, there is things that you is beyond your control. Then you claim to be innocent because of that. And sometimes you can say necessary or emergency. Defending. If I did not do the surgery, he would have been in worse condition than what he is now. He survived, but he is not as good. Still got not so good lah, but he survived lah. If I didn't do the surgery, he would have been worse condition. It was necessary. It was an emergency that we have to do the surgery. You cannot blame. You cannot blame the doctor that, or you can the blaming becomes less. It become contributory. You cannot have strict liability lah. Strict liability means everything the doctor have to be responsible for. Contributory, like the person on the motorbike uh, going around without a helmet and then meet an accident and going racing without a helmet. Or sometimes nowadays these young boys, they go on a motorbike and they sleep on the motorbike. They lie on the motorbike and they go. My area also got a lot of that. Told the police already, police never do anything. So if there is an accident, even though they are not at fault, but they are putting themselves in danger. Putting themselves in danger. So they have to be responsible by putting themselves in danger. They took the risk. They accepted the higher risk. So there will be a contributory negligence. Yeah. I also use this word extropy. Extropy means if the doctor or the lawyer or the architect, they do the design, they cut corners, they don't follow the rules guidelines set for architectural work. They cut corners to reduce the cost. They do illegal stuff, then becomes extropy. Extropy means we are not responsible for anyone doing any illegal, uh, who is involved in a legal activity. You have, if you do some illegal activity and you are responsible for it, the policy will not respond for it. This type of things that is also applies lah. So the whole idea about this liability insurance is that in liability insurance, the insurer and the policy holder are considered partners to defend against the third party who is the defender. Lah. So we are the defender, they are the plaintiff. So we defend to say how much responsibility we can take and how much responsibility they can take. That is why it is very important for the entire liability products. We cannot accept liability. We cannot negotiate with the third party. Don't worry, we will sort this out. Don't worry, we will pay you. Don't worry, I got insurance. Why do I pay you 5,000? We settle out of court. You cannot do all this pre-arrangement, agreement, promise, admit liability. You cannot, because that will make the insurer in a insuperior position. Make it difficult for us to defend. Our whole purpose is to see where we can defend. First of all, do we have a liability or not? Second of all, how to defend. And then I also highlighted you guys the other day that once there is a claim happen, somebody is sending you a suit to say we are suing you because we feel that you have breach of your professional duty, whatever it is. Uh, Take the letter and give it to the insurance company. Now, the insurance company will assign a lawyer to the case. They will review the policy wording to see whether the policy is uh, policy will be paying or not. Okay. Yeah. So from the time you put in the letter, the notification to the time the review is done to check on the liability, all expenses is incurred by Great Eastern. Your customer don't have to pay anything. Great Eastern will be bear all the cost. The moment they have read through the policy and make a decision whether they should defend or not to defend, the policy is not covered, you have to defend yourself, then what they will do is that they will transfer this responsibility back to you, your policyholder. Your policyholder now have to appoint his own lawyer and take the case themselves because the policy doesn't cover. Doesn't mean the policy doesn't cover, you cannot claim. You can still claim from the doesn't mean the policy not covered, you cannot defend. You still can defend yourself, but the third party still have a right to claim. Doesn't mean the policy does not pay, the third party got no right to claim. The third party always got a right to claim, whether or not it is valid, whether or not it is strict liability, whether or not it is contributory liability. All this is in the hands of the court makes the decision. This liability policy are the only policy that goes through the court straight away, compared to other policies. Other policies, we try to settle first. If you got a dispute, we try to handle arbitration process, we handle ombudsman process. If we cannot settle, then only we go to court. But liability, we still go to court because it is a lot of legal terms to see who is liable. And then some policy, as you saw the other day, also can include other things like comprehensive general liability as well. Okay. That is what I wanted to add extra. So let's see whether you have any questions here. Anybody wants to ask any question? I'm here now. I've covered the syllabus, but I think we can still take on some questions on the chat box, or unmute and talk also can, no problem. Any areas, public liability also can, general liability also can. or today's topic when we talk about products, there are a lot of products coming out in the market, especially food products. And then the manufacturer of the food products got to be very careful. These are your clients lah. In case people eat your product and they become sick, poison, sickness, illness, they want to sue. Branding can be destroyed. A lot of things can be destroyed. So you need to have proper product liability. Many people got this wrong interpretation. They say that only manufacturer can buy product liability. I was explaining to you what is product liability all about. I was taking you through the process of manufacturing, what happened, the product is what happened, the Consumer Protection Act, what it says, and then only I go to product liability. Yeah. So product liability, the coverage covers the coverage covers any death or injury from the product of usage of the product. Yeah, now I remember. I already forgot what I want to say, but now I remember already. So it is not necessary that you only look for manufacturer agent. Any distributor of products, they import the product from Japan, they import the product from China, they can distribute the product here. When you distribute the product, you are responsible? No. Duty of care. You're supposed to check the product is working or not. You're supposed to check, make sure that whoever used the product is not injured or suffer a financial loss or an injury. So even the distributor must have a product liability. So your customer is not only manufacturer, your customer can be the distributor. Now, the distributor distribute the product to all over, including retailer. The retailer sells to the all the retail outlet lah. Okay, the retailer also is responsible for the product. You go and buy from 7-Eleven a product. 7-Eleven is responsible for all the product in their 7-Eleven. If you take the product or battery or whatever and explode and you bought from 7-Eleven, you have a right to sue them. Anybody who does not get the duty of care to them by the other party has a right under the common law to sue the other party. That's what we're talking about, duty of care. So you have, and since you have a duty of care, you can sue them. They should have a policy. So you can now attack them also. You attack every retail shop, SME shop that are selling products, professionals who are giving advice, condominium, apartments, JMBs, error and omission is also liability cover. And most of the time, you need to sell public liability, because you are running a business. You get in touch with people directly or indirectly. The third party would have a contract with you, then directly they can sue you. If they don't have a contract with you, they can sue you as a neighbor. Remember I talked about the neighbor concept about the ginger beer, having the snail in the ginger beer. So a neighbor, you got also to take care of the neighbor. Yeah. So to take back the important aspects of whatever we have done, I just summarize for you lah. Number one, there must be a negligent, and negligent means a carelessness but unintentional. And we say negligent is part of the word thought. I don't want you to get confused. Some people tell you thought. Never use the word negligent. Then you say, does it say negligent? You're saying thought. Thought is C-word wrong. Everything wrong is called a thought. C-word wrong is a big name. Within the thought, there is a negligent. We are covering negligent. Not intentionally, not fraudulent, not dishonesty, but unintentional. Carelessness happened. That error and omission. Not that you purposely want to calculate the tax properly. Mr. Accountant, there was some error in your calculation, and then your submission to the tax office that you got someone extra. Not that you want to do it, it happened. because of some careless or miss out or wrong calculation. See, can happen. Not that the doctor wants to injure his patient. The doctor always do the best for the patient, but some things are beyond the uh, control, beyond his control. So we have to see if he is in control and he does it, then we will try to prove that this doctor is liable. No, and he do it. That is not negligent. That is more like deliberate act. Deliberate act. Could be fraudulent, could be uh, reckless. Reckless. Sometimes you cannot use the word fraudulent. Fraudulent means you're trying to do a fraud. Reckless. Reckless means you know that this is dangerous and you still want to do it. You want to go and jump into the river from on top of the mountain when you know you can get injured, but you're willing to accept the risk. When you're willing to accept the risk, you are part of the risk lah. Therefore, if anything happen, in case you are using the breathing apparatus or something product, you want to sue the product for not working while you jump into the river or the sea, they always will come back with a contributory negligence. Because you never you also are part of the risk lah. You assume part of the risk. So not always liability policies will pay 100%. Most of the time we will see that we can reduce the amount to make the other person also contribute some amount. That's why we say don't admit a liability. Okay lah, good. We have covered almost anything, all the areas that I wanted to highlight. Okay, I'm still waiting if anybody got any question. Otherwise, I will give back to Nurul lah. Yeah, Cik Nurul can take over. Thank you very much. Are you
All
there?
right, thank you so much to Mr. Justin for a wonderful sharing. And also, I would like to thank all value agents for attending our session today. For your information, we will share today's training slides to all participants. So you may grab it from your marketing or your servicing branch. And as usual, before we end our session today, kindly answer the Slido evaluation polling that I have uploaded. You may start to answer now. And for those already submitted the polling, you may leave this training room, and thank you again for joining us today. Have a great day, everyone.